Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It's Pam Esquire, also known as your law intellect. You guys come on in, hit that like button on your way in. Also hit subscribe if you haven't done so already. I am coming to you live from California. Yes, I am still on the road trying to bring you minute by minute, firsthand accounts of those cases that we have been following on this channel. Thank you so much to everybody that has already hit the like and everyone that has already subscribed. Welcome to all of my day one subscribers and welcome to all of my new subscribers. I thank you so much for giving our channel a try. Hey, Jeff. Hey, Stacy. That's the first twin, Butchie wife, Alice, Tarsha. Thank you for coming on over, supporting. Cotillion, Queen, St. James. Hey to everybody. I am here to do an update on none other than Tory Lanez. So you already know it couldn't just be smooth. It couldn't just be that we went on a plane, we went to the hearing, and then I had something just fantastic to report. You know, that hasn't been what's been going on in the last couple of weeks when I've been trying to track these cases in person. So we got here at about 2 a.m, took a little bit of a nap, got up because court was supposed to be at 10:30. Now, you know, there's a big time difference between where we're from and then coming to California. So we had to kind of adjust. So we get down to the court, downtown California, LA. And it was crowded. First of all, there were about 200 people, not exaggerating, waiting on the elevator at the court. And people were saying that they were waiting for like 30 minutes. So I don't know what in my mind said, Pam, you could walk these stairs. It's no problem, even though this case is on the 15th floor, even though the courtroom's on the 15th floor. Go ahead, girl, you got this. I started walking up those stairs, trying to get up there because I just was tired of waiting at the elevator with all these hundreds of people to get to the 15th floor. I started walking. I didn't know. I didn't have water. I felt like I was going to pass out. It was like the first 5 flights, I was like, oh, okay, I'm good. Then my knees started burning a little bit. I'm like, okay, this is not going to be easy. So I started trying to stop at the other floors, trying to press the button. I would wait like 15 more minutes, no elevator. So then I walked 5 more flights. I mean, this is what I do to try to bring you guys this firsthand, up-to-date information. So then I sit back, talk to a couple of people. You know, I meet somebody on each floor. So I go sit and I talk to people, and then I go walk 5 more flights. So I get up to the 15th floor finally, and it's like a lot of people there. So the last couple of hearing dates, I don't know if everyone somewhat knew that nothing was going to happen on this Tory Lanez situation, because we're waiting on he still hasn't been sentenced. And then his attorney, Jose Baez, who many of us know as the person that represented Casey Anthony, or the top mom, and miraculously got her off. We still don't understand how that happened. He is the new attorney. Now, David Kenner, who was a part of like, I think at one point he was a part of like, what is his name? I'm trying to think of. I can't think of his name. But anyway, he represented a lot of the top rappers like Suge Knight and Snoop and all of them. He was a part of Johnny Cochran, I believe, at one point. So anyway, everybody thought Kenner was on it, but I guess Kenner's not on the case anymore, but Jose Baez and his crew is on the case. So anywho, we're sitting in the hallway. We have a lot of YouTubers that were there, the same ones that were there for the most part the first time. And then we had a lot of people from the public. So how they do it is media, they already had a badge. If you already had a badge from the last time, you have priority. If not, then you had to stand in this long line trying to hope that you can get in to watch this case. So of course, Tory is remanded. For those that don't know, I'm sure everybody pretty much knows who he is. He is a rapper that was accused of using a firearm. Well, he was actually convicted of using a firearm that resulted in the harm to Meg Thee Stallion or Megan Pete. So his real name is Daystar Peterson. So anyways, we're sitting in the hallway and a lot of, we kind of became family from being in this hallway for 2 weeks, just talking and discussing. Everybody was happy to see each other. So then, we opened, we said, okay, they're about to start on time. We seen Tory's former attorney who actually conducted the trial. Then we seen Tory's family, his father and stepmother and the rest of his friends and stuff were there to support. Of course, like I said, the media was there, the same media people for the most part, and a whole lot of people from the public. So everybody thought something was going to happen today. So we finally get into the courtroom. It was a little bit after 10:30. Thank you so much, SD878, and I'm glad that you made our live. Well, we finally get into the courtroom, and so we're waiting, and so we see Jose Baez and his crew. They kind of go out to where the holding is, so I assume they were trying to talk to Tory. So I seen some people with post-it boards. So I said, oh, well, we're about to go ahead and maybe they're going to argue this motion to dismiss. So we got some play. So they go in, Jose Baez and it's another male attorney. He goes in and they go talk to Tory, come out. And then Tory comes out. He has the orange jumpsuit. He looked like he been eating well since he been in because he's, picked up a little weight. And he came out in his shackles and everything. And he had like this black knitted cap on the top of his head. So he came out kind of, did the nod at his friends and everything. And he sat down. So the judge starts out and was like, hello, everyone. And thank you so much for being here. On the first matter at hand is that Jose Baez, if you guys don't know, he is from Florida. As an attorney, if you're not licensed in these specific states, oftentimes you can request that the court do what we call pro hoc vice, which is one time only. So you fill out the application, you show you're in good standing wherever you're barred at, you have a sponsor from the other state, and they may let you come in according to their rules as the attorney. So Jose Baez is not licensed in California, so he had a pro hoc in. So the first order of business was basically whether the judge was going to allow him to even be the attorney. So the judge kind of started out like, yeah, I read your application. Your application, something was wrong with the application. But he said he was, I guess, over the procedural process, whatever rules he didn't apply to. The judge was allowing Tory to say, hey, these are the deficiencies. Do you still want him to be your attorney? Tory said yes. So he basically turned the eye, I guess, to any deficiencies, and he allowed Jose Baez to be the attorney. So I said, okay, well, we're about to hear this motion for a new trial. So then the judge says, if I understand correctly, defense attorney would like a continuance so that he can supplement his motion. Like what? So Jose Baez had asked the court if he supplement his motion for a new trial and come back on Monday. So we got all these people in the courtroom. I done flew here from Michigan, and they were like, "Oh, can we just come back?" I think it was probably, it had to be people waiting in the hallway. I don't think everybody was even allowed to come into the courtroom. So people have been waiting since early this morning, since they opened up the doors. So anyways, the government, they came in. It was DA Bott and DA Todd. They were the ones that conducted the trial for the government, for the prosecution. He just pretty much said, well, we were prepared to argue today. We filed our response to this request for a new trial. We already filed our response and we were prepared to go today. So yeah, we want to go today. And I'm like, yeah, I'm with the government. I want them to go today as well. No, the judge pretty much was like, okay, duly noted that you were ready to go today. And we're so glad you're prepared. But we're going to resume next Monday at 8:30 or 9:30 or whatever he said, because I just couldn't believe that he was postponing it so that we can discuss this. They can argue the motion for a new trial, which probably won't even have a decision from the judge. He probably will hold it in advisement. But what I wanted to discuss with you guys is, I know that you guys probably have heard of these motions, but I actually, of course, have the motions. We'll skim through. So everyone on here that's not familiar with the Tory Lanez case, they give a background, and it's going to be from the lens of the defense who filed the motion for a new trial, and then also the government's response. Now, just to warn you, the defense attorney has an 80-page motion for a new trial. 80 pages. The government responded with about 15, like with a cool 15. So we'll just skim through so we know what is being alleged, that there were deficiencies in the actual trial, that Tory Lanez team is asserting or arguing, and then we'll go with the government responses. And then whenever we get whatever this supplement is that he wants to wait a whole nother week, then we'll go over that as well. So hopefully you guys stick with me and we'll go through. It's 110 of you guys in the chat. If you guys could please hit that like button. I know some of you guys care about this Tory Lanez stuff. So this is the, as you see, Jose Baez, Pro Hoc VJ. We already went over what that is. This is a motion for a new trial. So the introduction, when they do their introduction, it's going to basically be their kind of rendition. They'll also cite certain parts of the trial transcript in order to, remember I told you guys, where's your authority, as their authority. So in the early morning hours of July 12, 2020, defendant allegedly used an unregistered concealed firearm to perpetrate a shooting, causing one individual, Megan Pete, to sustain injuries to her feet. Following an investigation, the state filed felony charges against defendant on October 8, 2020 in the Superior Court of California for the County of Los Angeles. Here's the case number. The matter proceeded to a jury trial. On December 23rd, 2022, the jury returned its verdict. The jury found defendant guilty of count 1, assault with a semi-automatic firearm in violation of Penal Code Section 245, finding the assault had been committed through use of a firearm causing great bodily injury to Pete, per Penal Code Sections 12022.5 A and D. You guys see all the numbers. The jury also found defendant guilty of count 2, carrying a concealed firearm within a vehicle in violation of Penal Code Section 25400, and of count 3, discharging a firearm with gross negligence in violation of Penal Code 246. Defendant now moves this court for a new trial based on the numerous errors committed at trial and the individual and cumulative impact of said errors, including but not limited to. So these are the errors that they are alleging should award their client, Daystar Peterson, aka Tory Lanez, a new trial. So they're saying the improper admission of an Instagram post and statement pertinent to alleged prior bad acts purportedly made by defendant, a violation of defendant's right to counsel of his choice, which is very interesting because everybody was asking about his former attorney. So they go into that. The admission of DNA evidence falling far short of comporting with industry accepted reliability standards, the use of radicalized character evidence through admission of evidence of defendants' tattoos and rap lyrics, and the violation of the Confrontation Clause as a critical witness testimony. In support thereof, defendant states the following. So we're going to go through the factual allegations as they see it from the defense side, and then we'll summarize each of the errors that they are alleging. Because as you guys see at the top here, it says 84 pages. We're not going through no 84 pages. We're really interested in this, but that's a lot. So, summary of the factual allegations. On July 12, 2020, at approximately 4:30 a.m., defendant, his security guard, Jaquan Smith, remember him, the one that showed up at the last minute, and two women, Kelsey Harris and Megan Pete, left a party at Kylie Jenner's Hollywood Hills home. The group left in defendant's black Cadillac sport utility vehicle. And when you see these parentheses that have, like, this has December 12, 2022, TR at 71, those are sites for the transcript where they got this information from. So I'm not going to go through that, but just so you guys are aware what that is. Defendant had a romantic history with both Pete and Harris. While inside of the vehicle, a verbal argument reportedly ensued between defendant Harris and Pete. Pete asked to exit the vehicle. Smith stopped the SUV in a residential neighborhood on the 1800 block of Nicholas Canyon Road. Pete exited the SUV and walked away from the vehicle with her back to the SUV and its occupants, intending to call another ride. As Pete was walking away, yelling from inside the SUV continued. Pete turned back around. As she did so, a firearm was discharged from the SUV in her direction and aimed at her feet. Defendant and Harris ran to Pete's aid, attempting to provide her medical assistance before helping her back into the SUV. The SUV headed in the direction of Pete's home. Pete was bleeding from at least one foot and expressed that she was in pain. Residents in the neighborhood called 911 to report a shooting. Officers from the Los Angeles Police Department Hollywood Division responded to the call. Officers en route to the scene noticed a vehicle matching the 911 call description approximately 1 mile from the scene of the shooting. They initiated a felony detention stop of defendant's vehicle. All passengers were commanded to exit the vehicle, and police searched the SUV. They discovered an olive green 9mm semi-automatic handgun on the floorboard of the front passenger seat. It was later determined to be an unregistered firearm. The owner of the gun was never determined. When officers observed Pete to be bleeding from her right foot, they questioned her about the source of her injuries. Pete stated she had not been shot. Instead, Pete told officers that she sustained the injuries from stepping on broken glass. Pete was transported to Cedars-Sinai Medical Center, where she received medical treatment for bilateral injuries to her feet, which included surgery to remove, quote, bullet fragments, end quote, from her feet. At the conclusion of the stop, Smith, Harris, and defendant were taken into police custody. Among the 2 males and 1 female arrested, defendant was the only one arrested on suspicion of carrying a concealed firearm with the vehicle in contravention of Penal Code Section 25400, and later charged in connection with these allegations. As part of an ongoing investigation, Pete was interviewed several times, including on July 16, 2020 and November 12, 2020. In these later interviews, Pete changed her original story and told LAPD Detective Ryan Stogner that she had been shot and defendant was responsible for firing the weapon. Pete claimed she had conveyed a different story on the morning of the shooting because she was scared, traumatized, and embarrassed. On November 12, 2020, Pete identified defendant through a single photo identification procedure. Not only had the statement of the primary complainant, Pete, changed, but as the investigation into the shooting continued, further questions were raised. Several other witnesses were interviewed and provided differing versions. No one except Pete could identify who discharged the gun. The gunfire came from the side of the vehicle that Harris had occupied. After the incident, Harris and Pete nearly immediately discontinued their long-term friendship and employer-employee relationship. Forensic testing did not resolve any of these questions. Both Harris and defendant had gunshot residue on their hands. And explicitly considering these GSR results and the wildly conflicting testimony versions of events, the only DNA sample collected for analysis in comparison to the firearm and magazine was the sample belonging to defendants. The test results ruled defendant out as a contributor to the DNA recovered from the magazine and were inconclusive. Then they go over the procedural history. We don't really need to go over that. All right, let's get down to it. We're not going over the applicable law. So, improper admission of Exhibit 48, the Shade Room Instagram post. At the 13th hour on December 13, 2022, the people sought to introduce a screenshot of an Instagram post from September 25th, 2020. The Shade Room, an entity unrelated to any party, published a post which contained a screenshot of a comment published by another non-party. I don't know how to say whatever his screen name is. The latter account is reportedly run by Pete's producer. The comment stated, "This goofy A and say he ain't shoot her," and they literally have matched the bullets from his gun to the ones in her foot. The captions to the image, which was purportedly authored by the Shade Room, read as follows: hashtag Megan Thee Stallion's producer alleges that authorities have matched the bullets from Tory Lanez gun to the ones found in her foot. In the comments to the post, a user going by Spiff K wrote, quote, "People saying Kelsey shot her," end quote, to which the account Tory Lanez, which the people allege was authored by defendant, although numerous staff members had access to the account as well, reportedly replied, quote, "That's not true." However, this post was not authored by defendant. Rather, beginning in December 2019, well before the post or the comment thereon were published, Joshua Ferris became the manager of defendant's Instagram account at Tory Lanez. So if you guys recall, there was a post that was being used and it was used at the trial, and many of us saw it because, you know, the Shade Room, when you comment at the bottom, they usually will repost their original post, and then any comments related to the people in the post, they'll put it on there. So somebody from Tory Lanez's account basically was saying it wasn't true that Kelsey shot Meg. So when the defense came in and they were basically trying to use that as an excuse, the government used, as a defense rather, the government used this post to say, well, how all of a sudden you saying Kelsey did it, but on this Instagram post, it specifically came from your account, and they had an officer, a detective that deals in social media, verified it was a verified account from Tory Lanez to basically say that Kelsey isn't the one. So what they're essentially arguing, to break it down, and they have an affidavit attached, it was not Tory, it was this Joshua Ferris who runs his account. And at the trial, Tory's attorney did emphasize that this officer that was verifying that this was Tory Lanez's account did not know, could not obviously tell who actually typed it. And that he did not know if Tory Lanez ran his own account or if somebody else did. So essentially, they're saying that that should not have been admitted. See, the court erroneously granted the people's motion to admit the Instagram post. On December 15, 2022, the court ruled on the people's motion to introduce the Instagram post, relying on the case law cited by the people on their motion, as well as another case. It held that if the people established that the account is linked to a certain individual, the contents of the post from the account will be admitted, as it goes more to the weight of the evidence than the admissibility of the evidence. The same day, the post was admitted into evidence through the testimony of the state's expert, Detective Warren Eberhardt. As discussed below, the court erred on numerous questions of law in allowing the people to introduce this post, depriving defendant of a right to a fair trial. The post was admitted in violation of a statutory notice requirement. That's their other argument, saying Section 1504 governs the scope and process of criminal discovery. which requires prosecutors to disclose exculpatory material evidence to criminal defendants, the statutory right to discovery. And that was another consistent thing. The defense attorney kept arguing during the trial that they were getting this new information that was going to be introduced at the 11th hour and that it wasn't fair and you're supposed to turn over all evidence. Even though we all watched Matlock growing up and all these, this is what irritates me about a lot of these law shows is they try to make it seem like it's all this ambush surprise witnesses, but no, we're not that type of a legal system. Everything we're going to use now, if you don't go over everything, like if they give you 1,000 pages and you as the attorney go over 2 of them instead of going over all of them, that's on you. But they're supposed to turn over any of the information that they plan on using in the discovery. So they're saying that they didn't give them notice of this information, and they have all the case law. You see, it's a lot of it. That's why I said they use so many. And the discovery violation amounted to a miscarriage of justice when it comes to that post. And there you have more case law. They also say the post amounts to inadmissible and inherently unreliable hearsay, not subject to any exceptions. So it goes through the California Rules of Evidence defines hearsay as a statement that was made other than by a witness while testifying in the hearing that's offered to prove the truth of the matter asserted. Hearsay is one, if you're in law school, going over hearsay and the exceptions and hearsay within hearsay and all of that is one of the main things when you have your evidence class that you go over. And I think a lot of people still don't understand, and we all kind of still get caught up in a lot of the hearsay. So they're trying to say this is hearsay. It's being used for the truth of the matter asserted instead of for some other reason. And they go through that. So as you see, there's a lot of pages in case law trying to substantiate that argument. And let's see. The hearsay evidence was improperly introduced through expert testimony. So as I told you guys earlier, there was a detective that was the one that pretty much said, hey, this is what his testimony was. I work for the LAPD. Part of my job is I look through social media. Somehow he verifies these accounts, I guess. Of course, nobody knows who's behind the keyboard, but he went through all the protocols on how he knows. Basically, he said the blue check shows that it's a verified account. That's pretty much all he said. And so he was used as the person to try to introduce and give the foundation of this being introduced. So then you have, oh gosh, it's another one on the introduction. Improper admission of alleged inculpatory statements by the defendant. That's on there as well. Thank you, Baby Dow Owens. I appreciate it. Inculpatory statements which tended to incriminate defendant as the shooter were improperly introduced at trial despite their factual falsity. On July 16, 2020, during an interview with Detective Ryan Stogner, Pete states that following the shooting, defendant exclaimed to her, quote, please don't say anything because I'm on probation. At trial, Pete testified that after the shooting, defendant said, I can't go to jail. I already got caught with the gun before. I can't go to jail no more. I'm already on probation. However, a further investigation concluded that defendant was not on probation at the time the case was happening, July 2020, nor had he ever been convicted of a firearms charge. Instead, he had been arrested in 2017 for a case that resulted in diversion out of Broward County, Florida. So essentially, this was another argument that came in. Apparently, in 2020, Tory Lanez had a gun charge in Florida, out of Broward County. That gun charge, we have a lot of states. I know we have it in our state. They have diversion programs. When you have a first offense, they may have you give you all these different stipulations to do. It might be go to anger management. It might be clean up the community. It might be community service, whatever it is. You have all these stipulations. And then if you complete these stipulations, when you go before the judge, they like hold your case almost kind of off in abeyance where if you complete this, then your case will be dismissed. So it sounds like he had a diversion program. But when Megan was testifying, she essentially was saying that Tory allegedly told her, please don't tell on me because I'm on probation. So in the defense's argument is, well, you knew that he wasn't on probation, so why would you elicit his testimony? Because he was never really convicted of this. This was a diversion program. So allowing that testimony, they're trying to say that that was also an error. I'm just summarizing it, y'all. You guys can all go look at this if you want to and for yourself. Defendant's right to counsel. Now, a lot of people ask me what happened to Sean Holly when they saw this other male attorney. And I think if you guys look at my other videos, I felt that they should have had a woman in this type of case. I thought strategically they should have had a woman. It at times looked very aggressive, in my opinion, for the attorney that was on this case. And so this is brought up in this motion. So this is what allegedly, according to the defense, happened to Sean Holly. So from near the inception of defendant's prosecution, he was represented by retained counsel Sean Holly, at least in part for tactical reasons. She is a female attorney, and he was facing charges alleging violence against a woman. On or around September 14, 2022, it was informally alleged by the people that defendant, being aided and abetted by his defense team, had extended a bribe to Harris by way of financial and or business benefits. When these allegations came to light, attorney Holly approached the prosecuting attorney, Kathy Todd, to express that the defense team was not involved in the alleged bribery, a position which the state apparently accepted as true at the time. Nonetheless, after representing defendant for more than 2 years, 12 days prior to the start of trial, attorney Holly stepped back in her role as primary counsel for defendant. Secondary counsel from the defense team, George Magdison. So apparently the guy that was there, Magdison, was actually a second chairperson, and he had to come forward because Holly had to step back. And Sarkis Manukai, I don't know his name. He's the second guy that was on there, I'm assuming. He didn't really do anything in the trial. He was just there. So I don't know. Stepped into attorney Holly's former role, diminishing the impact of defendants above described tactical maneuver of having female representation. Thereafter, the matter proceeded to trial with attorney Holly still on the larger defense team. Mid-trial on December 14, 2022, Harris was called as a prosecution witness, and when the people indicated their intent to pursue additional witness tampering charges against the defendant, a sealed sidebar hearing ensued. During the sidebar testimony, Harris claimed the defendant tried to offer her some favor in exchange for her not talking, including offering to hire an attorney for her. She further claimed defendant kept asking what else she wanted. What do you want to do? What do you want to invest in? And offered to invest in her business. Despite Harris's erratic and inconsistent answers and the people's earlier position that they did not believe attorney Holly to be involved in the purported bribery scheme, the people asked Harris on the record, and then he told you his attorney Sean Holly advised him to word such inquiries that way, referencing her purported earlier statements. Throughout the remainder of these proceedings, attorney Holly was twice more referenced by name in connection with the alleged investment plan. So what they're alleging, and you're going to see the government has a whole different reason why Holly wasn't there. And they have a letter to prove their side of it as well. But what they're basically alleging is that Holly, who has represented Tory before, basically it was some allegations of bribery to Harris to try to get her not to testify. There was also testimony elicited that this allegedly occurred, or that Harris testified or told the police this before, that Tory said, hey, what can I do for you? Can I get you an attorney? Can I do this or whatever, trying to keep her not to testify. So this is supposed to be allegedly why Holly didn't appear. And the defense is saying that stopped his right to counsel under the Sixth Amendment, because what their argument is. At that point in mid-trial, attorney Holly found it necessary to fully withdraw from her representation of defendant. This left defendant with 2 male attorneys as his primary representatives, fully eradicating his tactic-based representation plan. Claims pertaining to violation of a defendant's right to counsel fall within the purview of constitutional miscarriage miscarriage of justice. So that's what they're arguing, is that Holly was almost forced out. This was a part of their tactical plan. Y'all messed up the plan by making it seem like she was in some type of robbery scheme, and now he didn't get a fair trial. So they're saying the prosecution prejudicially interfered with defendant's right to counsel. So yeah, that's page 40. You guys see that at the top. So then they go through that. Just a bunch of case law. The prosecution's actions deprive defendant of a conflict-free counsel. And they say further, while the defendant unequivocally has the above described right to counsel of his choosing, above all else, the essential aim of the Sixth Amendment is a guarantee to effective advocate for each criminal defendant. It has a bunch of case law. There would be no trouble concluding there was a conflict of interest that was real, not theoretical, when trial counsel in a criminal case is worried that the prosecutor is scrutinizing his or her actions for possible criminal investigation, and her prosecution has a conflict of interest representing that client zealously. He or she does not want to antagonize the prosecutor. So again, they're claiming because the prosecutor is making it seem like Holly had something to do with some bribery on Harris, she was almost forced out. I told y'all this is just so long. So they also say the DNA evidence admitted against the defendant failed to comport with industry accepted standards in violation of defendant's due process right and resulting in a miscarriage of justice. That title kind of speaks for itself. They talk about the expert testimony. So they're challenging the expert testimony on the DNA. And they're saying the DNA evidence was also inadmissible. The admission was a miscarriage of justice. Evidence defendant is creative expression was improperly used against him at trial, depriving him of safeguards prescribed. So on January 1st, 2023, Assembly Bill number 2799, also known as the Decriminalizing Artistic Expression Act, took effect. The act limits the use of creative expression as evidence in criminal cases. So there's a lot of talk about prosecutors using lyrics against defendants. You guys see it in the case in Georgia, how they came with the whole RICO case with all the rappers using lyrics against them. So apparently just of January, there's actually a bill that was passed in California. We're not supposed to use creative evidence of creative expression. Apparently they say that half these rappers just making up this stuff. Like they don't really live this life. It's a persona. And so, which is amazing to me because you really do have kids that follow a lot of these people thinking they really are who they present themselves to be. And apparently they're not. They just make this stuff up for clicks, views, and paying, getting their record sales up. So that's pretty much what the argument is in the legislature. And so they're arguing that there was creative expression as the tattoo. So apparently, well, we saw the pictures. Tory Lanez has a tattoo of a GUN, and that was used by the government actually for identification purposes. But we all know, first of all, everything the government does is prejudicial. I mean, that's their point. They're trying to convict you. So they're not going to use things that's for you. So they chose the picture that showed a GUN on. He didn't have a shirt on, and they showed it on his chest. So they're saying that that's creative. That was just a part of this statute, and the statute that was just enacted should have been a part of this case to avoid all this stuff being in there. And let me show you. I think they put the reasoning why Tory has this tattoo. So this is what they're saying. Okay. Improper admission of defendant's tattoo as evidence of creative expression. At trial, the people were examining LAPD officer Sandra Cabral about the gunshot residue testing when they sought to introduce Exhibit 18, a photograph that appears to depict the defendant at the station at around the time of the GSR swabbing. A summary of the sidebar discussion is as follows. The sidebar is when they come to the bench, so we didn't hear any of that. So apparently they do have a court reporter that does transcribe everything that happens outside of the province of us as the spectators and also the jury. So apparently on the sidebar, defense counsel said, counsel's asking about the GSR and showing a picture of my client. There's no relevance to this picture. It will only sway the jury because my client looked like he has tattoos. The court said it's to show who the people are that she took a swab from. I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? Though the people stated they would show pictures of Harrison Smith, who were also swabbed for GSR from the same vantage point, and the judge overruled the objection. However, the pictures of Harrison Smith cannot earnestly be seen from the same vantage point when the defendant was the only one facing criminal charges. Instead, Exhibit 18 was racialized character evidence, and its admission into evidence was a deceptive ploy by the people, playing up racial stereotypes to imply defendant's guilt. The people's actual intent to inject racial bias into the proceedings through Exhibit 18 was revealed during their cross-examination of Eric Culberson, Pete's friend and business relation. After Culberson testified he had never seen defendant with a gun, the people asked Culberson, now defense counsel asked you if you've ever seen Tory talk about guns or if you've ever seen him with guns. Do you recall that? The people then asked, do you see the big gun that Tory has tattooed on the center of his chest? Defendant's tattoo was neither big nor relevant to the issue at hand, whether Culberson had ever seen him with it, yet the people use a tattoo for its literal truth by equating it to a real weapon to imply defendant does carry GUNs, evidence by GUN he carries on his chest. So they're trying to say the tattoo, the people were trying to infer that because he has it on his chest, he actually carries it. And so this is why Tory says he has a tattoo. Ironically, defendant's tattoo was in homage to his idol, Tupac Shakur. Mr. Shakur used his music and tattoos to discuss socio-political issues affecting the Black community in the 90s. Yet he too was misunderstood. Mr. Shakur carried the same AK-47 tattoo on his chest as a symbol of Black unity in the fight against racism. Thus, the meaning behind defendant's tattoo is quite the opposite of the meaning prosecutors designated to it, which jurors perceive. This type of unfair bias is the precise kind of highly prejudicial evidence of the code. And then improper admission of rap lyrics, kind of self-explanatory. And then they're saying the court impermissibly chilled defendant's right to testify. So apparently Tory wanted to testify, but when the prosecution said that they were going to admit certain information if he testifies, i.e. rap lyrics, because apparently there was some video where he was chopping up some horse legs or something, and it was like an inference from a lot of people that was pertaining to Meg Thee Stallion. So they said, yeah, if you get on this stand, then all this is fair game. And so I guess because of that, his attorney told him, hey, listen, you may not want to testify. And so they're trying to say because they were going to be allowed to use the rap lyrics that now Tory didn't want to testify. Admission of defendant's tattoos and rap lyrics was unfairly prejudicial. Defendant's rights under Confrontation Clause were violated regarding Harris's testimony. So this is the last one, I believe, because it was just, as you see, it's 80-something pages. So basically, we all know that Harris had done an interview and it was recorded. She gets on the stand, she pleads the fifth, she gets use immunity, and she changes her whole story. If anybody has been following this, she's changed everything. What ended up happening was, because there was some information elicited that almost made it seem like the prosecution had pressured her in some way or did something that was unethical, that conversation with the police that was recorded was allowed to be played, which we know played a significant role in his conviction, because once it was played, and honestly it was because the defense opened the door is what it was. Now, the defense isn't arguing that the door was open. They're saying that it shouldn't have never been played because after it was played, Harris had already been on the stand, so nobody could come and confront her about any of this video recording. And so they're trying to say that it violated his right to confront the witness because, again, that video was played, and Harris had already testified and said she don't remember anything and she lied about everything. So then they say the cumulative effect of the errors, basically he deserves a new trial. So that is the summary. I know it was long. That's the summary of what the defense. So how many actually believe? Do you guys think these are good arguments? Do you guys think? Yes. That was a big one. I thought after I watched it, the things that I heard in trial, I thought, of course, no defendant, it's not the defendant's burden of proof, it is the prosecution. However, there are certain testimony, once it comes out, you almost end up being forced to testify. And I think he should have testified. I said that, I think, on the previous videos when I was following. I believe he should have testified. But apparently, to me, that's not really a good reason not testify, that they're going to come out with things that's going to be impeach you or come against your credibility, because that's what they do. That's what the prosecution is going to do. That's what the defense is going to do in any case against the prosecution witnesses. I mean, they're not going to get up there and just let you tell your story in a narrative fashion and then the jury just says, oh, okay, I like his story. No, they're going to go against your credibility and they're going to try to cut you up. So I don't understand that being a reason, because you're scared of what might be introduced later, because they said they might introduce the lyrics if he gets on the stand. But hey, thank you so much. Thank you. I appreciate it. Tory is saying it should be dismissed. What do you mean it should be dismissed? Are you saying that the government's So are you saying that the defendant's motion for a new trial should be dismissed and he should be sentenced? Considering that they opened the door, not really, yeah. They're not arguing that they opened the door, but that was the reasoning why, from my understanding. There is a law, and you'll see from the government, there is a law that allows them, the government, to that allows them to play it. There's literally a law. So now we're going to quickly go over the government's. Theirs is a whole lot easier to go through because, like I said, theirs was like 80-something pages. You said appeal. This isn't an appeal. This is a motion for a new trial. So this motion actually goes back in front of the same judge who heard the case. And appeal, goes to the appellate. So he still has his appeal right. This is just a motion back in the regular courts, the trial court. Toria said, yes, just go to the sentence. Okay, got it. Just wanted to make sure I understood what you were saying. So this is the government's response. And they basically say in their introduction, in the memorandum, the defendant's motion for a new trial pursuant to Penal Code Section 11815 is under consideration. The defendant's brief is replete with colorful rhetoric and conclusory statements, but it lacks substance. Despite being nearly 80 pages long, the defendant has failed to cite a single instance of error in the trial court. Therefore, this motion should be denied. As the court is aware, the right to a fair trial is the cornerstone of our justice system. However, a motion for a new trial must be based on substantial legal grounds and supported by evidence. It is not a vehicle for a litigant to re-argue their case or to make vague and unsupported allegations. This memorandum will demonstrate that the defendant's motion for a new trial is without merit and should be denied. It will analyze the relevant legal authority, examine the evidence presented at trial, and demonstrate that the defendant has failed to meet their burden of proof. Ultimately, this court should deny the defendant's motion and uphold the integrity of the trial process. So basically, Toria, what you're saying, that's pretty much what the government's saying. So their facts and procedural background says on July 12, 2020, at approximately 4:30 in the morning, the defendant fired 5 rounds from a semi-automatic handgun at victim Megan Pete, causing her to sustain gunshot wounds to both feet that required surgery to repair. As you guys see, everybody's going to sway their facts. That's why I'm going to read both of them, because you're going to have your facts to be more favorable to your client. As you see, the government is like straight up. At 4:30 in the morning, the defendant fired 5 shots from the gun. That's not what happened in the defense. They're like, they go around it. Yeah, she was injured and all of that, but yeah, no. The incident took place after a party in the Hollywood Hills hosted by celebrity personality Kylie Jenner, which was attended by the victim, the defendant, and the victim's assistant and best friend, Kelsey Harris. At the time, the victim and see how they're calling Megan Thee Stallion, they're calling her the victim. They're not going to do that over there either. At the time, the victim and the defendant were friends with a brief romantic history. See how they downplayed this romantic history. The victim, the defendant, and Ms. Harris left the party together in a Cadillac Escalade driven by the defendant's security guard and driver, Joaquin Smith. While in the car, an argument ensued between the victim and the defendant. Ms. Harris intervened on behalf of the victim, accusing the defendant of disrespecting her, which led the defendant to threaten Ms. Harris, stating he would shoot her as he reached towards the center console as if to grab something. The argument escalated, and Mr. Smith pulled the car over on a residential road in the Hollywood Hills so the victim and Ms. Harris could get out. The victim and Ms. Harris exited the vehicle on the passenger side. As the victim was walking away from the car, the defendant produced a semi-automatic hand, yelling out, "Dance, Biat," and fired 5 rounds at the victim, striking her in both feet, injured the victim, crawled to the driveway of a nearby house. The defendant approached the victim in the driveway, apologized for his actions, and begged her not to say anything. He convinced the victim to get back in the car. Ms. Harris confronted the defendant for shooting at the victim, causing the defendant to physically assault Ms. Harris. He grabbed her by the throat and pulled her by her hair before calming down again. Everyone got back in the car. The defendant sat in the front passenger seat and the victim sat in back seat on the passenger side, and Ms. Harris sat in the back seat on the driver's side. The victim was bleeding profusely from her injuries. Witness Harris quickly sent a text message to the victim's security guard, Justin Edison, stating, "Help, Tory shot Meg, 911, end quote. A resident from the scene of the shooting reported the incident to the police, including a description of the car and license plate number. Officers located the car traveling in the area of Hollywood Boulevard and La Brea Avenue and conducted a felony traffic stop. Before the officers approached the car, the defendant begged the victim and Ms. Harris to keep quiet and offered them each a bribe of $1 million, which they summarily rejected. The defendant also attempted to bribe Ms. Harris a second time shortly after the incident, which was also rejected. Officers ordered the parties out of the car and conducted a search, during which they recovered a semi-automatic handgun on the front passenger floorboard where the defendant was sitting and was warm to the touch. Several cartridge cases were recovered from the shooting scene that matched the firearm recovered from the vehicle. The victim initially told officers that she sustained the injuries to her feet by stepping on glass. She was in shock, scared, and embarrassed about what happened. 4 days later, once removed from the excitement of the situation and with a clear head, she told the truth about what happened. The defendant and Ms. Harris never made a statement to the police. Ms. Harris said only that he didn't see or hear anything. DNA testing was conducted on the recovered firearm, but the results were inconclusive. Gunshot residue tests were performed on all the occupants except for the victim, who was transferred by ambulance to Cedars-Sinai Medical Center. The defendant and Ms. Harris were both positive for gunshot residue, while the driver, Mr. Smith, was negative. The defendant was arrested for possession of a concealed weapon during the ongoing investigation into the shooting that occurred less than 5 hours earlier. While in detention, he made a jail call to Ms. Harris in which he expressed deep remorse for his actions, admitting that he made a mistake that he can't take back, quote. He acknowledged that he was, quote, just so effing drunk, end quote, and that the victim may never speak to him again. On December 23rd, 2022, a jury convicted the defendant, and it has all of the counts. So as you guys see, this is a whole different colorful rendition. Actually, all this stuff did come out in trial with testimony. But just to see how the different factual versions occur in the case, it's just starkly different. So then they go through the argument, which is the standard. Okay. Defendant's motion for a new trial should be denied. The court properly admitted People's Exhibit 41A. The defendant argues that the court erred by admitting People's 41A on 3 grounds. First, the defendant claims that the people violated their statutory discovery obligation by failing to timely turn over the reply from the defendant's verified Instagram account containing the exhibit. Second, the defendant argues that the reply from the defendant's verified Instagram account is inadmissible. Third, the defendant contends that the exhibit of the post also contained inadmissible hearsay. However, the court correctly admitted the exhibit and the defendant's arguments are without merit. The Instagram post, the issue in Exhibit 48, was published by the Shade Room, so it goes through the same thing. During the trial, Detective Warren Edhart investigated the Instagram post to lay foundation for admissibility, and both parties briefed and argued the issue during a motion in limine. You guys, I talked about a motion in limine. It's basically before you even go to trial, you try to bring any potential evidentiary issues before the judge. So you say, I want this out or I want this in with a motion in limine. So apparently there was a motion in limine that was already talked about before the trial started that the judge ruled on whether this Instagram post should be admitted. The court ruled that the evidence was admissible based on the case law cited by the people and the court, at which point it gave the defense an opportunity to be heard further. The defendant maintained its objection to the admissibility of the exhibit, but never asked for a continuance or for a late discovery instruction on this issue. The failure to ask for a continuance is particularly important considering that the defendant now claims the response was purportedly authored by a social media manager, Joshua Farias. However, assuming the declaration by Mr. Farias is factually accurate, the defense had ample opportunity to call him as a witness with reasonable diligence and could have asked for a brief continuance in order to produce him if necessary. So the defendant now contends that the people violated the disclosure obligation under Section 105.4.1 with respect to Exhibit 48. This argument is without merit as the discovery was already in possession of defense on September 25th, 2020, when the defendant's own verified account commented on the Instagram post. The defendant is essentially complaining about late disclosure of information that was already under his agency and control for over 2 years. So essentially they're saying, you're trying to say we withheld the evidence from you, but this is your account. So if this is your account, you already had this information before we had the information. So how you saying we failed to turn it over? And furthermore, if you had an issue with us like submitting this, you could have asked the court to adjourn this, have a continuance, and then have this person that did this affidavit and said he was really the one that said whatever this comment was because he controlled the account. He could have came in and testified, and you guys forfeited that. So yeah, kick rocks. So they potentially, they have the case law for it on here saying basically it was admissible. So they go through that. Then they have evidence of defendant's statement regarding probation was properly admitted. The defendant argues that the victim's testimony regarding the defendant's statement, please don't say anything because I'm on probation, was improperly admitted at trial since it is false and prejudicial to the defendant. However, the context in which the statement was elicited is important. It was revealed during the victim's direct examination wherein she was asked about the things the defendant said to her right after the shooting. She testified that the defendant urged her not to speak about the incident, offered her and Ms. Harris $1 million to keep quiet. He claimed he couldn't go to jail as he was already caught with the gun before and on probation. The defendant's motive for making the statement was to manipulate the victim and Ms. Harris into keeping silent. The defendant's argument fails to consider that whether or not the defendant was actually on probation is immaterial, since he said what he believed was necessary to maintain their silence. Thus, the court did not err in admitting the evidence at trial, and the defendant waived this issue by failing to object at trial. So apparently his attorney, when you are complaining about something, you have to be able to preserve the record. So you should have objected. So they're saying Tory's attorney never objected. Further, this information was not used as for the substance of whether he was on probation, whether Tory was on probation or not. Nobody cares about that. They're saying the point was that's what he was trying to use to manipulate her into not testifying. So it wasn't even used for the purpose that the defense is trying to say it was used. Then they have case law for that. And then this is about the defendant's Sixth Amendment right to counsel. This is what I was talking about earlier. It was not violated according to them. So the government says the defendant argues that the people violated the Sixth Amendment right to counsel by eliciting testimony from Kelsey Harris about defendant's mention of his attorney, Sean Hawley, and his attempt to solicit a bribe. However, this claim is inaccurate, misleading, and unethical. So they saying that the defense even saying this and bringing this to the court is inaccurate, misleading, and unethical. The defendant attempts to shift the blame onto the people for an issue he created himself. Furthermore, the defendant's claims regarding Holly's withdrawal from representing him without a supporting declaration from Holly are false and an intentional misrepresentation to the court. In a letter submitted to the court on January 10th, attached as Exhibit A, Holly explained that her absence from the defendant's trial was due to her engagement in an out-of-state arbitration and not related to the defendant's claims. The defendant's claim is therefore a fraud upon the court. The court should reject this claim. Additionally, the defendant's claim under the Sixth Amendment are waived and forfeited because he failed to object to the evidence at trial, did not seek to exclude it during a motion in limine, and did not object when the evidence was presented during the Harris's testimony. And they did attach an Exhibit A, guy. This is from Holly. So the defense is basically trying to say that Holly didn't represent him, which is a part of their strategy, because there was some type of insinuations that there was fraud. So I'm not fraud, but bribery. And they didn't have an affidavit from her that that was the reason. But the government actually attached a letter in their Exhibit A showing her reasoning. So this is Judge Hereford. This is from Sean Holly. As the court is aware, I did not appear at Mr. Peterson's trial due to my engagement in an arbitration out of state, which began in May and did not conclude until December 16, 2022. Mr. Peterson understood and agreed that George Magnuson would represent him at trial and that I would not. I am advised that attorney David Kenner has now been retained to substitute in his counsel for Mr. Peterson. Though it may not be necessary for me to do so under these unique circumstances, I thought it important to advise the court that I have no objection to the substitution and hereby offer my consent thereto. So this was sent to the court on January 10th, 2023. So that was their response to that. All right. So I think they came with their receipts on that one. Then they talk about the admission of the DNA evidence was proper. We don't need to go over that. The admission of a photograph of the defendant's tattoo in question regarding the tattoo of defense character witness was proper. The defendant claims the court erred by admitting Exhibit 18, a shirtless photograph of the defendant showing his tattoos and questions to defense character witness Eric Culberson about one of the defendant's tattoos lacks merit. The admission of the photograph was relevant for several reasons, such as to compare the witness's description of the party's appearance with their actual appearance and to determine who was swabbed for gunshot residue by members of the Los Angeles Police Department. Basically, they were doing it for identification purposes. The court conducted an evidence code section 352 balance test and correctly admitted the exhibit over the defendant's objection on prejudice grounds. Okay, so basically that's that. The court did not chill the defendant's right to testify. The court's inquiry into people's intended impeachment evidence was appropriate and in line with its duty to ensure a fair trial. The court did not preclude the defendant from testifying or limit his right to testify, but rather indicated that any questioning would be evaluated on a case-by-case basis. It must be relevant to the case. The defendant's argument that the court chilled his right to testify is unsupported by the record and fails to recognize the court's responsibility to ensure a fair trial for all parties. The court did not violate defendant's right under the Confrontation Clause. Now, this is about Harris being able to play the recording when she did the interview with the detectives. That's the big thing that everybody talked about. The defendants claimed that his right to confront and cross-examine Kelsey Harris was violated by the people's admission of the September 2020 interview with Ms. Harris is unfounded and contradicts the holding in Crawford v. Washington. The Confrontation Clause of the Sixth Amendment requires that a defendant be given the opportunity to confront the witnesses against them. However, Crawford specifically addressed the admissibility of hearsay statements made by a witness who did not testify at trial. The Crawford decision does not apply when the witness testified at trial and is subject to cross-examination by the defense. Kelsey Harris testified and was extensively cross-examined by the defendant, so his claim under Crawford is without merit. Furthermore, the court properly allowed the people to play the entire taped interview because the defendant suggested during his cross-examination of Ms. Harris that the people acted unethically by pressuring her into lying when she gave her September 2020 statement. This issue is similar to the one presented in People v. Ruiz. In that case, the defendant implied the people had engaged in misconduct during his cross-examination of a government witness. In response, the prosecutor sought to introduce a tape recording of a conversation between the defendant and the informant, which had been previously excluded from evidence. The defendant objected, but the court allowed the recording to be played, finding that the defendant had opened the door to its admission by implying that the people had acted unethically. The recording provided context for the defendant's comments and allowed the jury to evaluate the credibility of the defendant's claim. Similarly, in United States v. Skilling, the court held that a defendant can open the door to the admission of evidence by making statements that suggest misconduct by the prosecution. In such cases, the court may allow the admission of evidence that would otherwise be excluded in order to provide context or rebut the defendant's claim. In this case, the defendant's suggestion of misconduct by the people opened the door for the entire September 2020 interview to be admitted into evidence, and the court properly allowed it. Therefore, the defendant claims that his right to confront and cross-examine Ms. Harris was violated should be rejected. So, so essentially, if you guys don't recall or didn't follow back in December when I was here just doing the, actually sitting in the courtroom and doing my lives after the hearings, the defense, he was doing all right. Like, Kelsey testified that she felt pressure, and that's why she did the interview that was recorded. The defense rightfully came and they asked her, well, did you feel pressured by us? Did my client pressure you? And she said no. It could have ended right there. But what he did was he kept pushing and said, well, did the prosecution pressure you? And he started getting into what the prosecution did. So once he got into that, it can be inferred by some people that the prosecution acted unethically in some way. Now, mind you, the judge had ruled at first that this tape was not going to be played. But because he started making insinuations, and under the case law that they have here in Skilling and Crawford, essentially, when you make any type of insinuations that the prosecution acted unethically, then you basically open the door and they can prove that they didn't act unethically and that it was all fair play. So that's what happened with that. so that's it. So Tory said, I agree with the prosecutors, dismiss this motion, judge, and let's move up the sentence of hearing and send him off to prison service time. He is a career criminal. Oh my goodness, Tory. Coco said, I really appreciate all the hard work you do for us. Thank you. I appreciate it. Hey, Cupcake. Thank you for coming over. Hey, Keela. All right, that was it. I just wanted you guys to see. I know there were articles about there being a motion for a new trial, but we never went over, we always go over the documents. We don't just go by what's in the paper. Hopefully you guys have an understanding of what all of their claims are. So apparently now, if you missed the beginning, the judge has allowed the defense, I guess after they got this response, they wanted to supplement it and add more information. So they asked the judge for more time to supplement it. And then that's supposed to be argued on Monday. So I can't say whether I'm gonna be here for that or not, because this is getting out of control. I'm like, none of these people actually do what these dates. Thank you, Tracy Bailey, for the Cash App, and thank you, Beverly Settles, for the Cash App. I appreciate you guys. Thank you for hanging out with me. I know it's starting to get late on the East Coast. So if you guys can hit that like and subscribe, let everybody know we over here talking about Tory Lanez as well. If I have any updates on anything else, of course, tomorrow I'll be back on to talk about those, because we have a hearing that's supposed to take place tomorrow as well on the other guy. So we'll talk about that as well. But anyways, I'm going to talk to you guys later. I'm about to go hang out in these streets, and I'll talk to you next time.